I'm Lauren Comito, and welcome to this episode of the First Amendment on Trial. For this episode, our entire social media and public relations class took ownership of different promotional components of the program. We are working as a group of 15. Colleague Alec Bacall animated the opening graphic for our series. The logo was designed by my colleague Meredith Charles. These are solid examples of experiential learning, or learning by doing. If you are lucky enough to attend Robert Morris University, you'll build a professional portfolio as you earn college credits. We are live in the RMU-TV studio with audience members from our Moon and campus communities. Joining us via web streaming are Cornell, Weir, Propel, and PA Cyber High Schools. Thanks for joining us. The First Amendment on Trial, freedom of speech and freedom of assembly and petition was made possible by a grant from the Free Speech Center at Middle Tennessee State University. Professors Ann Summerall-Jabro and David Jameson were awarded the grant for designing an inclusive learning experience that involves 3 academic units at Robert Morris University: communication, political science, and the Academic Media Center. We are all about intellectual experiences at RMU, and this one includes our audience too. Your job is to listen carefully, determine which of the debaters researched and presented a compelling case to persuade you that their argument is the best. At the conclusion of the debate, we will all cast a vote for the most effective argument. Get ready to listen attentively and cast your vote. There are no winners or losers from this experience because we all learn something instrumental about our disciplines in real time. And you are learning to listen effectively, think critically, and render a judgment on the quality of the arguments presented. At the conclusion of the show, you'll be asked to vote for the debater that presented the most compelling case. Thank you for joining us today and for listening carefully to the arguments. And now to Professor David Jameson to introduce today's topic.
Thank you, Lauren, and welcome again to the final segment of our series, The First Amendment on Trial. Throughout this series of programs, we have had an opportunity to explore some of the most important and significant and personal freedoms that we enjoy as Americans, the freedoms guaranteed by the First Amendment of the Constitution: freedom of religion, freedom of speech, freedom of the press, and freedom of assembly and petition. To help us understand these freedoms, Robert Morris University criminal justice and political science students have researched significant cases from U.S. Supreme Court history. In these programs, students present the argument to the court in cases reflecting these First Amendment freedoms. As in a real First Supreme Court appeal, each advocate will argue their client's position and be prepared to rebut the arguments of their colleague or opponent in today's case. Today's First Amendment topic is freedom of speech and freedom of assembly and petition. The framers of the Constitution themselves had frequently met in public assembly, petitioned the King of England about their grievances. They felt that the right of individual freedom of speech was vital to American liberty, but also that Americans must be guaranteed the right to speak in groups, to demonstrate, to air their grievances, even in strong and challenging rhetoric. Today, 2 Robert Morris University student advocates will argue whether burning the flag in the context of a political demonstration should be protected by the First Amendment. Our advocates for this case are Daniel Pollack and Sydney Brooks. Daniel is a senior majoring in political science, and Sydney is a sophomore, also a political science major. Representing the judiciary as our presiding judge is the Honorable Philip Harold. All rise.
Good afternoon. You may be seated. I remind those in the gallery to please remain quiet during oral arguments. I will now hear case number 19414, State of Texas petitioner versus Gregory Lee Johnson, respondent. Counsel, please enter your appearances.
Dan Pollock, Your Honor, representing the state of Texas.
Sydney Brooks, representing the respondent, Gregory Lee Johnson.
Thank you. I will remind counsel that each of you will have 15 minutes for oral argument and 5 minutes for rebuttal. Mr. Pollock, please proceed.
May it please the court.
Please proceed.
Your Honor, the issue before the court today is whether the public burning of an American flag, which occurred as part of a demonstration with political overtones, is entitled to First Amendment protection. To summarize the facts of the case, in the summer of 1984, the Republican Party held its national convention in Dallas, Texas. During the convention, a group of 75 to 100 demonstrators who identified as the Revolutionary Communist Youth Brigade marched through Dallas to protest the policies of the Ronald Reagan administration. The demonstrators paraded through the streets, shouted chants, destroyed property, broke windows, and threw trash and beer cans. One of the demonstrators removed and stole an American flag hanging in front of a bank building and gave it to the defendant, Mr. Gregory Lee Johnson, who was one of the leaders of the demonstration. When the march ended, Mr. Johnson doused the flag with kerosene and set it on fire in front of Dallas City Hall. While the flag burned, protesters chanted, "America, the red, white, and blue, we spit on you. You stand for plunder, you will go under." While no one was physically injured, some eyewitnesses said that they were extremely offended by the flag burning. The defendant, Mr. Johnson, was arrested and charged with violating the Texas flag desecration law, which states that it is a misdemeanor crime for someone to knowingly desecrate a state or national flag, where desecrate is defined as deface, damage, or otherwise physically mistreat in a way that the actor knows will seriously offend one or more persons likely to observe or discover his action. Mr. Johnson was convicted and sentenced to 1 year in prison and a $2,000 fine. The Intermediate Court of Appeals in Texas affirmed the trial court's ruling of a conviction. Mr. Johnson appealed the ruling to the Texas Court of Criminal Appeals, which is the highest court in the state of Texas to hear criminal cases. The Texas Court of Criminal Appeals overturned the conviction, ruling in favor of Mr. Johnson. The Court of Criminal Appeals held that the Texas flag desecration statute was unconstitutional as applied to Mr. Johnson since he was a political protester. They also found that flag burning constituted symbolic speech and said that Texas's interests in regulating the act of flag burning do not outweigh a political protester's First Amendment right to freedom of expression. For today's argument, we, the state of Texas, will assume that flag burning is symbolic speech, but we will still argue that Texas has a compelling interest in regulating flag desecration. Today, I am asking the court to overturn the Texas Court of Criminal Appeals ruling, as the Texas flag desecration law is constitutional, and the law was certainly violated by Mr. Johnson. The first argument that I will make to the court today is that the First Amendment is not absolute, and expressive conduct demands less constitutional protection than pure speech. In this case, we are ceding that Mr. Johnson's flag burning constitutes symbolic speech. However, symbolic speech does not deserve the same degree of constitutional protection as pure speech. Expressive conduct like burning the American flag should not be protected under the First Amendment. Symbolic speech inherently has more power than pure speech. Words can cause an impact, whether good or bad, but expressive conduct or symbolic speech will cause a much bigger impact than pure speech. Sometimes symbolic speech is so powerful that it has to be regulated by government, so as not to cause damage to society. The Texas flag desecration statute is one of those necessary regulations in order to protect society and protect American society's national symbol, the American flag. Let us remember, Mr. Johnson was arrested and charged for burning the American flag. That sole action is what he was punished for. Mr. Johnson was not punished for any pure speech. Mr. Johnson and other demonstrators protested by marching through the streets, shouting profanities, chanting their disdain for America, and chanting their disdain for American politicians. All of these forms of Mr. Johnson's political speech were protected, but his flag desecration was over the line and not protected by the First Amendment. Mr. Johnson desecrated the greatest symbol of American unity in existence, and he could have caused a breach of the peace as a result. For this reason, Mr. Johnson's action is not subject to First Amendment protection. Additionally, the Texas statute is extremely narrow and still allows Mr. Johnson to have several other ways to convey his message. The second reason why the Texas flag desecration statute is constitutional is because the state of Texas has a legitimate interest in enforcing it. The Texas flag desecration statute advances two substantial interests. One, the protection of the flag as an important symbol of nationhood and unity, and two, a prevention of a breach of the peace. For more than 200 years, the American flag has occupied the unique position as the symbol of our nation. It is the visible manifestation of over 200 years of history in this nation, and its design has largely remained the same over time. The 13 stripes represent the original 13 colonies, and the 50 stars on the flag represent each state. The preservation of the flag as a symbol of nationhood and national unity is a compelling and valid state interest. The state of Texas has the right to preserve the physical integrity of the flag so that it can continue to serve as a symbol of national unity. The symbolic effect of the flag is diluted by acts of flag desecration. If people are permitted to desecrate the flag as they please, the flag will gradually lose its symbolic importance and special nature over time. We, the state of Texas, are merely asking for the physical integrity of the flag to be preserved. Individuals remain free to criticize, dishonor, and demonstrate disrespect for the flag, so long as they do not physically desecrate the flag in any way. Individuals are not required to have any respect for the flag. We are merely requiring that they do not physically desecrate it. Additionally, the statute only prohibits public flag desecration. If an individual desecrated a flag in private, it would probably not be punishable under this statute. The statute uses the least restrictive means to achieve this goal. While allowing public desecration of the flag would broaden freedom of speech, it is not worth tarnishing the value of the most important symbol of this great nation. The unique nature of the American flag justifies a government prohibition on flag burning or desecration, especially in the manner that Mr. Johnson carried out his action. The second state interest that the Texas flag desecration statute advances is a prevention of a breach of the peace. Mr. Johnson's flag desecration had a tendency to incite a breach of the peace. We feel that preventing a breach of the peace is a legitimate state interest. The Texas legislature judged that public flag desecration is likely to lead to violence. We are merely fortunate that a breach of the peace did not occur in this particular case. While it did not occur in this particular case, public flag desecration, especially flag burning, has the potential to be dangerous. Flag burning could incite a riot or other dangerous events that would disturb the peace. Flag burning has a very high likelihood of leading to further illegal action, meaning that the state of Texas should be able to sanction it to avoid this. Public flag burning will do one of two things. It will either motivate fellow protesters to commit other illegal acts, or it will offend and anger witnesses in the public, who may be motivated to respond with force in order to protect their flag. Either way, flag burning ignites a passion that could become dangerous. The Texas flag desecration law punishes this potentially dangerous type of expression and protects the public. There is certainly a substantial interest in restricting flag desecration as a proactive measure to prevent a breach of the peace. The third and final reason why the Texas flag desecration law is constitutional is because the Texas law is a valid time, place, and manner restriction on demonstrations. Historically, the court has ruled that time, place, and manner restrictions can be imposed on otherwise free speech to limit it in when, where, and how it can be expressed, as long as the government can express a rational relationship between the regulations or restrictions and the social interest. This was established in the Supreme Court case Ward versus Rock against racism. In this case, we believe there is a rational relationship between the Texas statute and the social interest, which makes the law constitutional. The Texas flag desecration statute establishes two main time, place, and manner restrictions on demonstrations. The first restriction is that the flag desecration cannot be done in a way that the actor knows will seriously offend one or more persons. In other words, flag desecration cannot be carried out in public. The purpose of this restriction is to protect the social interest of preventing a breach of the peace, since flag burning is likely to upset some witnesses. Enforcing that the flag not be burned in public in order to avoid a breach of the peace is in society's best interest. It is more than reasonable to say that the Texas statute's restriction on public flag desecration has a rational relationship with the social interest. The second restriction is the primary substance of the law, which is simply that you cannot desecrate a state or national flag. The rational relationship between this restriction and the social interest is simple. The flag is a symbolic unifier of the 50 states and the people of this country. In dishonoring the flag in a manner as heinous as flag desecration would dilute the symbolic effect of the flag, which would not be good for society. It is in society's best interest if the flag remains a strong symbol of nationhood and national unity. So there is certainly a rational relationship between the Texas statute's restriction of flag desecration and the social interest. Both of the two main restrictions in the law are narrowly tailored so as not to infringe on an individual's First Amendment rights. The Texas flag desecration law says nothing about other forms of speech that could be used to criticize the government, politicians, or America in general. Mr. Johnson was free to verbally denounce the flag in any manner that he wished, and he was free to publicly burn other symbols of the government or the country during his demonstration. None of that would have been punished. Mr. Johnson verbally attacked President Reagan, Walter Mondale, and the United States, none of which he was punished for. It was only when he burned the flag that his expression crossed the line and violated the Texas statute. It is abundantly clear that the Texas statute's restriction is extremely limited to still allow a great deal of individual liberty and to preserve the right to protest. There is certainly a rational relationship between the Texas statute's time, place, and manner restrictions and the social interest. In summary, the First Amendment is not absolute, and expressive conduct demands less constitutional protection than pure speech. The Texas flag desecration statute advances two substantial interests. One, the protection of the flag as a symbol of national unity and nationhood, and two, a prevention of a breach of the peace. Lastly, the Texas law is also a valid time, place, and manner restriction on demonstrations. For these reasons, I ask the court to overturn the Texas Court of Criminal Appeals ruling, as the Texas flag desecration law is constitutional and the law was certainly violated by Mr. Gregory Lee Johnson. Unless there are any questions, I'd like to reserve the remainder of my time for rebuttal. Thank you, Your Honor.
Thank you, Counselor. Ms. Brooks, please proceed for the respondent.
May it please the court?
Please proceed.
Your Honor, burning an American flag as a form of protest as committed by my client on August 22nd, 1984, is undeniably a form of protected, free political speech for the following reasons. Firstly, the act of flag burning committed was a constitutionally accepted form of political speech. Secondly, the Texas law which prohibits the action of flag burning is unconstitutional. And lastly, that outrage over the burning of the flag is not enough justification to suppress free speech under law. Now, I would like to note that my client Johnson maintains that he did not actually ever burn the flag, but even if he did, that is still a protected form of free speech. The flag burning took place during an obviously political protest. And because this protest was obviously political, the way that speech is protected changes. Political protest is our most protected form of speech in the Constitution, and for good reason. Without political protest, we are not able to act as political actors within our country. The 1931 Stromberg versus California case has already placed a precedent that the absence of words in no way diminishes the First Amendment rights for protection of political speech. This means that symbolic speech is just as protected as pure speech under a constitution. Lastly, there was no threat of violence at the protest. There are many video and photo evidence of the protest. Throughout the protest, there was no violence. Because there was no violence, the state of Texas has no right to restrict this speech. Secondly, the Texas law that was grounds for Johnson's conviction is unconstitutional. The 1973 law outlawed mistreating a state or national flag in a manner that the actor knows will seriously offend one or more persons likely to observe or discover this action. In 1968, an O'Brien case put towards the test for strict scrutiny under political speech. This law made that, the 1968 O'Brien case placed the strict scrutiny test for restricting political speech. Under this case, the Supreme Court has ruled that there must be certain things that must be taken before a law restricting political speech can be considered constitutional. Firstly, this law has to have a substantial government interest for being used. Secondly, the government interest has to be unrelated to the suppression of free expression. And lastly, the restriction on the First Amendment must be achieved by the least restrictive means possible. This Texas law does not defeat this test. Firstly, as a substantial government interest, protecting citizens in the case of burning a flag. This does count as a substantial government interest, but it is related to the suppression of free expression. My client Johnson burned the flag, and in no way was this something that created any form of violence for those around. Of all people that were bystanders to the burning of the flag, they were offended, but there was no proof that the offense led to anything that would cause further violence or anything other of that nature. And lastly, to this point, this law is not content-based because it only protects a positive view of the flag. This law allows for respectful desecration of the flag. If the flag as a symbol of the American country would be diluted as a symbol because it's being destroyed, then the Texas law should not allow people to burn the flag for reasons such as respecting our veterans or other things that would uphold the symbolic nature of the flag. Because people are allowed to burn the flag for reasons that uphold the symbolic nature of the flag, this law is unconstitutional. And lastly, the serious offense provision of the statute is unconstitutionally vague. If I were to ask anybody in the audience what the word serious offense means, everyone would give me a different description. This term is undefinable. There's no way to measure the level of offense for people that are witnessing a protest. And how many people that need to be offended in order to invoke a law is also vague within the Constitution, within the law. It also fails to inform potential violators as to what content is forbidden. The law says that physical mistreatment of the flag is unconstitutional, but there's no specifics as to what physical mistreatment is unconstitutional. As I have previously stated, it's okay to burn the flag in situations where you're upholding the symbolic meaning of the flag. So that's stating that burning the flag is fine in certain situations, but there's other ways that mistreatment of the flag could be considered, such as stepping on it or using it as a blanket. Those things are considered constitutional. Wearing the flag as your wardrobe, you could wear your flag as a shirt, as pants, as socks, which once again would be stepping on our flag, but that's still considered constitutional under this law. The First Amendment is not on the basis of public reaction, and the point of the First Amendment is not to support ideas that were popular. If that was the necessity, we would never need the First Amendment rights towards free speech. The reason why the founding fathers wrote the First Amendment in order to protect free speech is to protect forms of free speech that are unpopular. Our founding fathers wanted to repeatedly speak out against the king, and they were worried constantly that they were going to be arrested and persecuted for this, which is why it was so important for the First Amendment to be written. The right to political speech is also our ability as political actors to influence the government. Without our right to protest, we no longer have any influence on the government at all. In conclusion, because flag burning is considered symbolic speech, the Texas statute was unconstitutional, and because public opinion is not grounds to suppress political speech, my client, Gregory Lee Johnson, was within his rights by burning the flag on the date in question, and the ruling should be upheld. Thank you.
Thank you, Counselor. Mr. Pollack, you have 5 minutes for rebuttal.
May it please the court?
Please proceed.
Your Honor, just a few quick points that I wanted to touch on. First of all, my opposing counsel tried to claim that the Texas law is unconstitutional because it restricts symbolic speech. We already ceded in our opening argument that it is symbolic speech, but we're saying that because of the unique nature of the American flag, Texas still has an interest in enforcing the law. She also mentioned that just because that there was not a breach of the peace in this particular case, but just because there wasn't a breach of the peace in this case doesn't mean that there couldn't be in other cases. And also, that's highly arguable considering Johnson and the other demonstrators were breaking windows, destroying property, throwing trash and beer cans. So that could be considered a breach of the peace. Additionally, my opposing counsel claimed that this Texas statute did not pass strict scrutiny. I do not find that to be the case. The strict scrutiny test asks two questions. Does the law serve a compelling state interest, and is it narrowly tailored? In other words, does the law use the least restrictive means to accomplish this state interest? The law does serve a compelling state interest because it protects the flag as an important symbol of nationhood and national unity, and it prevents a breach of the peace. The flag has a long history of being a symbolic unifier of the 50 states that make up the Union. No matter what state you are in, you will see the American flag flying with a star for each one of the 50 states. The flag is a symbol of the nation, the people of the nation, and the rights that the people in the United States have. The flag desecration statute protects the flag since it is much more than cloth. Additionally, the law prevents a breach of the peace. The public desecration of the flag, especially burning, has the potential to be dangerous. In Brandenburg v. Ohio, the court ruled that speech is unprotected if it advocates imminent lawless action, a true threat, and is likely to produce it. The desecration of the flag certainly has the potential to do this. Flag burning, in particular, could incite a riot or other dangerous events that would disturb the peace. In fact, it is rather likely that flag burning will be followed up by some other illegal actions. As previously stated, the group of demonstrators destroyed property, broke windows, and threw trash and beer cans. So before the flag burning even started, illegal actions were already occurring. The flag burning did nothing to stop this, but rather encouraged more illegal action. Under Brandenburg, the state can punish speech or expression that advocates imminent lawless action and is likely to produce it. The Texas flag desecration law punishes this type of symbolic speech and protects the public. People will unquestionably be offended by flag burning, and it could certainly cause counter-protesters to respond to someone like Mr. Johnson with force. There is certainly a compelling state interest in making sure that something like this does not happen. Secondly, why it passes strict scrutiny. The statute is also narrowly tailored as it merely prohibits public flag desecration in a way that the actor knows will seriously offend one or more persons likely to observe or discover his action. In other words, the law prohibits flag desecration around the presence of others or in public. The law does not prevent anyone in Texas from desecrating a flag in their own private place, but they merely cannot perform this action in public or in the presence of others. Further, the Texas law does not prohibit any other forms of protest or speech criticizing the U.S. government, any other state governments, or any politicians. Almost any other type of protest to send political messages can still be expressed, but this law is narrowly tailored to flag desecration. Lastly, the law only prevents state and national flags from being desecrated. Other political or governmental symbols or items could still be burnt without punishment from the state of Texas. For these reasons, the flag desecration law is narrowly tailored. And since the law is narrowly tailored, it passes strict scrutiny. Lastly, my opposing counsel claims that Mr. Johnson's action constitutes political expression and therefore is protected speech. I would just briefly like to explain why Mr. Johnson's action did not really constitute political expression. Mr. Johnson's action did not really constitute political expression because it did not really express any ideas. The American flag alone does not represent or endorse any political party, political philosophy, or political ideology. As a result, burning the flag is not really a political statement. Flag burning merely has the goal of causing a positive reaction from fellow demonstrators and a negative reaction from those who will be offended by the burning of a national symbol of unity. But politically, flag burning has no meaning. Once again, I ask the court to overturn the Texas Court of Criminal Appeals ruling, as the Texas flag desecration law is constitutional and the law was certainly violated by Mr. Johnson. Thank you, Your Honor.
Thank you, Counselor. Ms. Brooks, your rebuttal.
May it please the court?
Please proceed.
My opposing counsel mentioned that flag burning was over the line and that the strict scrutiny test was passed by this Texas law. The restriction on the First Amendment was not achieved by the least restrictive means because flag burning is only illegal under this law if that flag burning is for a protest that is against America. In reality, my client, Gregory Lee Johnson, was not arrested for burning a flag. He was arrested for burning a flag because he was against Ronald Reagan's policies and against the Republican National Convention. Had he been burning the flag to say that he was pro for the Republican National Convention, there would not have been an issue at all. Because this is a content-based law on those who want to protest against America, it is not achieved by the least restrictive means. Johnson's view of the American flag was that it was a symbol of an imperialist system and that flag burning was a symbol of total rejection of the system and a powerful political statement. Because he viewed the flag as something different, burning the flag had a different meaning for him. The symbolism of the flag is not always one that represents the flag as something that's positive. And as Americans, it is our right to burn the flag if we choose, as a form of political protest. In regards to the time, place, and manner restriction and the rational relationship between this law and burning the flag, it does not meet these standards either. Once again, because the flag can only be considered an illegal burning if this flag is being burned in a negative manner to the country. Lastly, my opposing counsel mentioned that the flag is the only symbol that cannot be desecrated. It could easily be argued that there are plenty of other symbols of America that represent our country better, but we're allowed to burn all of these things. I could come up here and burn the Constitution, and that would be legal. I could burn any other symbol that represents America, and that would be constitutionally accepted. The flag should be no different. The flag is not a specifically special symbol, and it should be allowed for us as political actors during protest to burn the flag if we choose. Thank you.
Thank you, Counselor. Ladies and gentlemen, we have heard arguments on both sides of this important question. I now ask that those in the gallery and participating via simulcast to cast their ballots for which advocate presented the most compelling argument. As you vote, let me reflect on the importance of a case like this and on the quality of the arguments presented by our student advocates. At issue in Texas versus Johnson is Texas's flag desecration law, which said that we cannot desecrate a flag in public. Mr. Pollack represented Texas, Ms. Brooks represented Johnson. The trial court and appellate court ruled for Texas, but the Texas Court of Criminal Appeals ruled for Johnson. Texas appealed to the Supreme Court. The petitioner, Mr. Pollack for Texas, had three main arguments. He ceded that Mr. Johnston's burning of the flag was symbolic speech, but that it does not deserve the same protection as pure speech. Second, Texas had a legitimate interest in enforcing the law. First, protecting the flag as a symbol of nationhood and unity, and second, preventing a breach of the peace, the fact that burning the flag could inspire other illegal actions. And his third argument, that we can restrict speech based on precedent because it is a valid time, place, and manner restriction. The respondent, Ms. Brooks for Johnson, also had three main arguments. The flag burning was expressive political speech and so is protected. The burning took place during a political protest. Also, there was no threat of violence. The Texas law itself is unconstitutional insofar as it discriminates against the negative use of the flag. And third, the law in Texas is too vague. It cannot be defined when it bans actions that seriously offend. And it fails to inform us what conduct exactly violates it. This issue is very important today. Political speech is the most important type of speech. It's constantly at risk. Any fundamental critique of the political system will offend people. We are in a politically polarized time, and so it certainly remains very important today.
Join us in the Academic Media Center for the First Amendment on Trial debate series every Thursday until November 21st at 1:30 p.m. Our PR campaign focused on making people aware of the First Amendment rights. Thank you for joining us to learn about the First Amendment rights afforded to you and to judge our debaters. Our student debaters spent countless hours researching and writing their cases and presenting them for us today. Our audience members listened attentively and selected Daniel Pollock for the most effective case. It's been a learning fest for us all. Thank you for joining us.